My name is Phyllis Pollack, and I recently gave a presentation on California's new rule of professional conduct, Rule 8.3, regarding the reporting of misconduct of other attorneys to the state bar. And I thought that I would share that presentation with you so that hopefully, after about 15 minutes of this video, you will have a basic understanding of what the state bar requires under Rule 8.3 in terms of reporting misconduct of other attorneys to the state bar. The presentation is California Rule of Professional Conduct 8.3 in a nutshell. And in order to understand it, I'd like to go through a little bit of the history. The ABA has had Model Rule 8.3 in existence since 1983. And up until August 1 of 2023, California was the only state not to have implemented it. In other words, 49 other states had implemented 8.3 or something similar. But then, both in 2010 and in 2016, the State Bar Standing Committee on Professional Responsibility and Conduct, or COPRAC, investigated about considering whether to implement Rule 8.3, and in both instances, it declined to do so. But then along came Thomas Girardi, who was a very well-known attorney in California, a plaintiff's attorney who settled and litigated many mass torts. Soon after his wife, Erica, filed for divorce in November of 2020, it came out that Mr. Girardi had been engaged in embezzling client funds for his personal use, indeed well over $2 million. And he'd also committed various other violations of the California Rules of Professional Conduct. Disciplinary charges were filed against him in March of 2021, and he was eventually disbarred on July 1, 2022, and ordered to pay $2.3 million in restitution. It also came out that since 1992, although there had been over 205 complaints lodged against him, he remained in good standing. And this might lead one to think that a lot of the other attorneys in the State Bar of California or members of the State Bar were aware of his conduct, but because California did not have a Rule 8.3 in existence, they remained silent. In May of 2023, the State Bar issued a report that revealed that to the extent that these clients did complain, those complaints were not really investigated or were simply dismissed due to a lack of evidence. So in light of this scandal with Tom Girardi, and indeed it made all the headlines throughout the state, in November of 2022, the chair of the Board of Trustees of the State Bar directed COPRAC, that is the Standing Committee on Professional Responsibility and Conduct, to prepare a proposed new rule on reporting attorney misconduct to the State Bar. And in doing so, the chair asked the committee to look at the Model Rule 8.3, variations of the rule used in other jurisdictions, and look at its own past considerations in 2010 and 2016 of Rule 8.3. And as I said, this was in mid-November of 2022. To push the State Bar to act, though, Senator Umberg introduced Senate Bill 40 on December 5th of 2022, which was essentially the Model Rule 8.3. That is, Senator Umberg was laying down the gauntlet, telling the State Bar that if it did not act affirmatively to implement a Rule 8.3 or something similar, the legislature would do it for it. So in January of 2023, COPRAC put out for comment for 30 days a narrow version, or what we call Alternative 1, of Rule 8.3. It received 89 comments at its public meeting on February 15, 2023, and of those comments, 58.6% disagreed, 30% agreed only if the rule was modified, and 11% agreed with the rule. So it went back to the drawing board, and on March 3rd of 2023, it recommended a revised proposed rule to the Board of Trustees. But meanwhile, its staff also prepared an alternative, which we call Alternative 2, and submitted it to the board with requests that both Alternative 1, Alternative 2, the Model Rule 8.3 itself, and the option that no version be adopted be submitted to the public for 40 days of comment period. The board did so, and so submitted Alternative 1, Alternative 2, the actual Model Rule 8.3, and then the option that no rule be adopted. The public comment period ended May 4th of 2023, and at that time, the State Bar received 390 public comments. Of those, approximately 51% preferred that no version of the rule be adopted. Only 17% preferred Alternative 2, but nevertheless, in mid-May, the Board of Trustees submitted to the Supreme Court for review and consideration Alternative 2, as well as the legislative proposal SB 40 or Senate Bill 40 proposed by Senator Umberg. The Supreme Court made some additions and modifications and revisions to Alternative 2, and by order dated June 21 of 2023, it ordered that Rule 8.3 would go into effect in the state of California on August 1, 2023. So in light of this, and in light of the actions of John Eastman leading up to and including January 6, 2021, Senator Umberg amended his Senate Bill 42 to no longer concentrate or parallel Rule 8.3, but to provide that treason, sedition, or insurrection must be reported to the State Bar. And as I will say in a moment, this Senate Bill 42 was rolled into Senate Bill 40, which is the California State Dues Bill, which, as we know, was signed by Governor Newsom in mid-October. So let's take a look at Rule 8.3. It has two subparts. The first subpart is the mandatory reporting obligation, which means that in connection with the actions listed on this PowerPoint or on this slide, the attorneys must report the following types of misconduct to other attorneys, and they include criminal acts, dishonesty, fraud, deceit, misrepresentation, whether it's reckless or intentional, misappropriation of funds or property, and such misconduct must be reported if it raises a substantial question regarding the attorney's honesty, trustworthiness, or fitness as an attorney. Now, the term criminal acts is a defined term. First, it refers only to acts that would be criminal in the state of California. If an act is criminal in another state or under federal law, but is legal in the state of California, then it is not reportable. And an example of this would be marijuana, which is legal in California, but not under federal law. Criminal acts also include those establishing moral turpitude, such as dishonesty, fraud, and more severe crimes, such as murder and sexual offense. They also include repeated criminal conduct, such as DUI or substance abuse, whether they actually harm or have the potential to harm other people, even if it has nothing to do with the practice of law. It also includes violent crimes, as well as an attorney's lack of respect for the legal system. Now, the term substantial is also a defined term under Rule 1.01, and it means a material matter of clear and weighty importance. So that's the mandatory part of the rule. Let's look at the permissive. Basically permissive reporting is required for any other rule of professional conduct and or of the State Bar Act. So examples would be if there's a violation of the conflict of interest rules or a violation of the rule about sexual relations with a client, or perhaps threatening criminal or administrative charges to gain an advantage, or perhaps failure to manage or supervise attorneys, which is covered by rules 5.1 to 5.3, perhaps the failure to communicate settlement offers, which is covered by rule 1.4.1, or perhaps trying to limit your liability to a client, which is covered by rule 1.8.8. But with regard to permissive reporting, when you are deciding whether to report the attorney, one must consider the seriousness of the other attorney's offense and the potential impact that it might have on both the public and the profession in reporting. Now, there is also a duty to self-report. Rule 8.4.1 prohibits discrimination, harassment, and retaliation, both in representing a client and in the operation of a law firm. Subparts D and E provides that an attorney who is being investigated by the state bar or the state bar court for such conduct must notify the state bar if any civil, criminal, or administrative charges for that same conduct have been brought against him or her. The attorney must also notify the California Civil Rights Department, formerly known as the DFEH, as well as the EEOC, of charges brought by the state bar under subparts A and B of the rule. Now, Business and Professions Code section 6068E also has a reporting requirement. It provides that within 30 days of the time that attorney has knowledge of the following instances, the attorney must report in writing to the state bar of the instance. And those instances include the filing of 3 or more lawsuits in a 12-month period against the attorney for malpractice or other wrongful conduct committed while practicing law, or the entry of a judgment against the attorney in a civil action for fraud or misrepresentation, breach of fiduciary duty, or gross negligence while in the practice of law, the imposition of a judicial sanction against the attorney of more than $1,000 for something other than discovery violations, the bringing of an indictment or information that charges a felony, or the conviction of a felony or a misdemeanor of the attorney. As I said, Rule 6068o lists several instances, and I've only recited a few of them. So I would encourage you to read the rule to gain a fuller understanding of what it requires. So when to report. The duty to report arises when an attorney knows of credible evidence that another lawyer has engaged in the conduct, and it must be reported without undue delay. Now, the term knows is defined to mean having actual knowledge of the fact in question. And the term credible means an issue for the trier of fact. And as I said, it must be reported without undue delay. Now, where to report? You can report it to the state bar, and the California Supreme Court, as part of its modification to the rule, put in the second part that if the litigation is pending, you can report it to tribunal, and tribunal is a defined term under the rules of professional conduct to include not only courts, but administrative agencies as well. So you can report it to a tribunal if it has jurisdiction to investigate and act upon the misconduct. You cannot report it to a private arbitrator because the private arbitrator does not have the power to act upon the misconduct. So you have to report it, as I said, to either the state bar or to essentially the court. So the rule is retroactive in the sense that if the lawyer knew or had credible evidence of another lawyer's breach of the duty prior to August 1, 2023, then ipso facto, the lawyer has that knowledge on August 1, 2023, and thus has the duty to report. Now, there can also be abuse of the rule. Attorneys are still prohibited from threatening to file a state bar complaint for purposes of gaining an advantage in litigation. They are also prohibited from making a false or malicious report to the state bar or offering false testimony to a tribunal. And lastly, but not in the least, they cannot agree or seek an agreement to prevent the reporting of attorney misconduct under either these rules or the Business and Professions Code, section 6090.5. So let me go back to Senator Unberg, but before I do that, let me talk about the exceptions. Rule 8.3 has several exceptions, which means that there is no reporting required if, and I, as a mediator, the most important exception to me is the mediation confidentiality, which means that if an attorney commits alleged misconduct during a mediation, then I, as an attorney, am not required to report it because that conduct is excluded under 8.3. Other exceptions include Business and Professions Code 6068E, which, as we all know, provides that attorneys are to maintain and violate the confidences and at every peril to ourselves to preserve the secrets of our clients. Also, there is no reporting requirement for a violation of Rule 1.6, which is about confidential information of a client, nor about Rule 1.8.2, which is regarding the use of a current client's information. Information gained under the attorney-client privilege is also not reportable. Information gained under applicable privileges or other rules of law is also not applicable. And these latter two could conceivably include information gained during an arbitration. As many of you know, arbitrations are confidential, and in order to determine whether arbitration confidentiality applies, one will have to look at the arbitration rules, and more specifically, Standard 15 of the Ethics Standards for Neutral Arbitrators and Contractual Arbitration. But yet, bear in mind, California Evidence Code Section 703.5, which renders both mediators and arbitrators as not competent to testify except in certain instances. Now, there are some other exceptions. For example, they include the duty to report does not apply to a lawyer who is consulted or retained to represent a lawyer whose conduct might be in question. And it also does not apply where a lawyer is consulted by another lawyer about the possible misconduct of a third lawyer. The reporting requirement also does not apply where the information is gained by using the ethics hotline or some similar service. And it also does not apply where the information is provided as part of a substance use or mental health program, such as the Attorney Diversion and Assistance Program, also known in the state of California as Lawyers Assistance Program. So those are the exceptions, but as I said, let me go back to Senator Umberg for a moment. Senator Umberg, as originally proposed, his Senate Bill 42, proposed a new Business and Professions Code section 6090.8, which, if you look at A and B and compare it to the ABA Model Rule 8.3, closely parallels subparts A and C of the Model Rule. But then, when he learned that the Supreme Court was going to act, he changed the emphasis from Model Rule 8.3 to be towards treason, sedition, and insurrection. And the legislative analysis of this rule states the reason is that in light of that, recently the State Bar of California had announced formal charges against attorney and law professor John Eastman for his role in advocating for the overturn of the 2020 presidential election and in generating a legal theory that underpinned the January 6th insurrection of the United States Capitol. So Senator Umberg decided to change the emphasis from the model rule to the idea that a licensee of the state bar is now required to report another member who has conspired to engage in or has engaged in treason, sedition, or insurrection against either the state of California or the United States. Any attorney having such knowledge about another attorney must so report it. But notice that the exceptions are very few. The only exceptions are information protected by the attorney-client privilege or information gained by a licensee while participating in the attorney diversion and assistance program. Then in mid-September, the format of the rule changed, and as you can see, they are now parts A, B, and C of subpart A, and they now include seditious conspiracy, treason, rebellion, or insurrection as prohibited under both state and federal law. And it is now section 6090.8 of the California Business and Professions Code. It was signed by Governor Newsom on October 10, 2023. And again, the exceptions are very narrow. It includes only the attorney-client privilege or information gained by a licensee while participating in the attorney diversion and assistance program. So that means that if you are, let's say, a mediator or an arbitrator, and one of your parties makes a threat to overthrow the government or commit treason or rebellion, you may well be required to report such conduct under 8.3, since this new Business and Professions Code does not cover mediation confidentiality or other applicable privilege. But I will leave you with that thought and for a discussion on another day. So I thank you very much for your time. And if you do have any questions, please feel free to contact me. You may reach me either by email, phyllis@pgpmediation.com, or by the phone number 213-630-8810. Thank you very much for your time.